On May 6, 2025, a preliminary hearing took place before Judge Michael McGinn at the Woodhaven District Court in Woodhaven, Michigan. The prosecution was handled by attorney Muhammad, while the defendant, Sergio Bello, was represented by defense attorney Lillian Dio. To grasp the context of this proceeding, it's essential to understand how such hearings function under Michigan law. A preliminary examination, often called a probable cause hearing, occurs when an individual is charged with a felony. During this process, the judge reviews witness testimony and evidence presented by the prosecution to decide whether a crime was committed and whether there is reasonable cause to believe the defendant was involved. If the judge determines that probable cause exists, the case is bound over, meaning it advances to the circuit court where major felony trials are held. In this case, Mr. Bello was charged with assaulting, resisting, or obstructing a police officer, as well as third-degree fleeing and eluding law enforcement, both classified as felonies in Michigan. The prosecution's duty during the hearing was to provide sufficient and credible evidence for Judge McGinn to find probable cause and transfer the case to the Wayne County Circuit Court for further proceedings.
Any other preliminary matters? Mr. Mohammed?
No, not from the people.
Ms. Diallo?
None, thank you.
Thank you. Call your first witness.
People call Officer Gregory Brewster.
Okay. Officer, stand up, please. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do.
Okay. It's Gregory?
Yes, sir.
Brewster.
Yes, sir.
Okay, Mr. Mohammed, you can proceed.
Thank you. Good afternoon, Officer Brewster. Can you please restate your name to the record?
Lieutenant Brewster, Trenton Police Department.
Okay, Lieutenant Brewster, are you currently employed?
Yes.
Who is your employer?
Trenton Police Department.
And in what capacity are you employed there?
I'm a patrol lieutenant for the police department.
Okay, and were you employed in that capacity as a patrol lieutenant on January 26, 2023?
No, I was a patrol sergeant.
Okay, and on that day, did you work?
Yes.
On that day of January 26, 2023, did your duties as a police officer take you at or near the location of 1875 West Road?
Yes.
Is that located in the city of Trenton, county of Wayne?
Yes.
What took you to that location?
I was there for an unwanted subject.
Okay, and what is at that location?
It's at a gas station.
Okay, and upon making that location, what did you do, if anything?
I made contact with the clerk who called.
Okay, and what did you learn?
Oh, I'm gonna object this to hearsay.
Any response?
Judge, I didn't ask about any specific statement. I'm just asking the officer what you learned since his investigation.
At least it's overbroad. Sustained, rephrase. Is this the gas station on the corner of 4th and West?
Yes, sir. King's Mobile.
Thank you.
Okay, so sir, you indicated you had contact with the clerk?
Correct.
Okay, why did you have contact with the clerk?
That was the call.
Okay, and after having contact with that clerk, did it have any effect on you? Did it cause you to make your next decision?
Yes.
Okay, Your Honor, at this time, I think the statements by the clerk would come in under effect on the listener. The officer indicated.
We'll ask her next question. She can object if she wants.
Okay. Officer, what did you learn from the clerk that caused you to further your investigation?
Wait 1 second.
So Judge, I am gonna object to hearsay. So I think the way we might do this is based on what you learned from the clerk. Did you do something as opposed to her words?
Assisting.
Okay, officer, based off of what you learned from the clerk, did you do something based off of those statements?
Yes.
Okay, what were the statements that that had an effect on you and caused you to change your steps?
She told me.
Wait, no, that's hearsay. I object.
Sustained.
Thank you.
I'll just move.
What did you do next, sir? After speaking with the clerk, what did you do next?
I made contact with the person that the clerk called.
And where was that individual located?
Standing next to a vehicle near the gas pumps.
Okay.
See, I could still do this, Ms. Diallo. 31 years later, I could.
How many?
31. Believe it or not. Go ahead.
Officer, please rise, the judge instructed. Raise your right hand. The bailiff or court clerk then administered the oath. Do you swear or affirm under penalty of perjury that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth to the best of your knowledge? I do, the officer responded. Very well, the judge said with a nod. You may take your seat and will continue with your testimony.
Okay, and the individual you made contact, where was he standing exactly?
Next to the vehicle.
Okay, can you describe the vehicle?
This is a red Fusion.
Okay. And was there anybody that was sitting in that vehicle?
No.
Okay, was there anybody else besides that individual standing outside of that vehicle?
No.
Okay, now that individual that was standing right outside of that, was it a Ford Fusion?
Yes.
Standing outside of that Ford Fusion, do you see that individual in the courtroom today?
Yes.
Can you please point to that individual and point out an article of clothing that individual is wearing?
A black suit coat.
Your Honor, please let the record reflect the witness has identified him.
Record should so reflect.
Thank you. And did you initiate contact with that individual that you just identified when you were at the scene on that day?
Yes.
How did that begin?
I don't remember my exact words, but I think I said, "Hey, what's going on?" Or
Okay.
How's it going?
What happened next?
The radio in the car was very loud, and I believed it was going to be difficult to have a conversation with the person. And I asked to turn the radio down. I said, "Can we turn the radio down?" Something to that effect.
Okay, besides that, was there any other observations that you made?
When I first made contact with him, I noticed
And who's him, just for the record?
the defendant there.
Okay,
When I first made contact, I noticed that the person was unsteady on his feet and he had red eyes, red bloodshot eyes.
okay, and based on your training and experience as a police officer, what is that indicative of, if anything?
I believe that he was under the influence of something.
Okay, and so what happened next?
Against my better judgment, he sat in the car to, I believe, turned on the radio, but that's not what happened.
Okay, what happened next?
The person attempted to put the vehicle in drive and
Oh, okay, before we get to that, where did that individual sit?
dressed.
Okay, at that point, was the vehicle on or off?
It was on.
Okay, and after that individual sat in the driver's seat, what happened next?
The person put his foot on the accelerator and tried to put the vehicle into gear.
How do you know that?
So I saw it.
Okay, and what happened next?
I told him to stop twice,
Okay,
very loud,
okay, and why did you tell him to stop?
because I believed he was trying to leave.
Okay, and when you told him stop the first time, did he say anything in response or do anything?
No,
Okay,
he continued to try to put the car into gear.
okay, and what about the second time? What happened after that?
Same thing. He continued his actions,
Okay, and what was his actions that you were observing?
that he was trying to put the vehicle into drive.
Okay, what happened next?
The vehicle got into drive and the driver of the vehicle left.
Okay, and the driver of the vehicle, just, I want to confirm for the record, that's the same individual you identified here in court?
Correct.
Okay, and what happened after that?
The vehicle drove east towards one of the entrances / exits to the gas station onto 4th Street.
Okay, and do you recall what the posted speed limit is on 4th Street?
On 4th Street, it's 50 miles per hour.
Okay, and based off of your observations, what did you do?
My vehicle was parked on the opposite side of the gas station. So I ran back to my vehicle, got my vehicle.
So just so I know, you were on the west side of the building? Is that where you were?
My vehicle was parked on the west side of the building. I walked into the gas station and then I walked out.
So now when you were confronting him, you were on the east side of the building?
Correct.
He pulled out and started traveling southbound on Fort?
No, northbound.
Northbound, okay.
And you indicated that the posted speed limit in that vicinity is 50 miles per hour?
On 4th Street, M85, correct.
Okay, and what did you do next?
I ran back to my patrol vehicle to get in and attempt to pursue.
Did you attempt to pursue him?
I never turned my lights on. I thought I saw the vehicle turning north onto now the northbound lanes. So my assumption was that the vehicle went.
You may object to speculation.
Okay, so you can testify, and I'll keep on record that portion up to my assumption was.
Okay,
All the rest is strict, that language is stricken. You can ask your next question.
I would agree that it is. And so what did you do after that?
I saw a vehicle turning from eastbound West Road to northbound 4th Street. I believed that vehicle was the vehicle that I was after, because I saw taillights of that vehicle turning. So I drove south on the 4th Street to hit the turnaround to try to catch back up to it, to go back northbound and catch up to that vehicle.
Okay,
There's a no left turn signal there, is there not?
Yes.
So in order to turn from eastbound West Road onto northbound Fort, he had to disregard that signal, correct?
Yes, sir.
And you turned back southbound on Fort, did the Michigan turn, and now we're heading back northbound on Fort.
Yes, sir.
okay, and were you able to locate that individual, the defendant?
No.
Okay, and so did you learn anything else pursuant to your investigation?
I returned to the gas station and spoke to the clerk.
Okay, and what did you learn?
Oh, no, I would object just to hearsay, anything she said. Thank you.
I learned that
Wait a minute, slow down, slow down.
Judge, I'm not asking for a specific statement, so there's no specific out-of-court statement. I'm just asking the officer what you learned pursuant to his investigation.
Any response to that?
So I think you can ask, and this is just me, I don't know, it's up to the judge. Based on your investigation, what did you do next without saying the specific words? Because we know hearsay is a statement offered by the declarant, other than while testifying at the trial or hearing, offered to prove the truth of the matter asserted.
Wow.
I've been 30 years too, Judge.
Go ahead,
I would
Mr.
agree.
Muhammad.
Officer, based on your investigation, what else did you discover based on your interaction with the clerk?
I learned that I went the wrong way and was pursuing the wrong vehicle.
Okay, and did you learn the correct way that the individual fled from the scene?
I learned that the vehicle went, I saw the vehicle turn north onto southbound 4th Street, but I learned that it did not go that way. It went west on West Road.
Wouldn't that be hearsay, Judge? What you learned? Because you had to learn it through hearsay. So I would ask that that be stricken objection hearsay. And speculation.
And Judge, I would disagree. I think there's no specific out-of-court statement that's being offered. I think the officer is just testifying to what he learned pursuant to his investigation. There isn't a specific out-of-court.
You have to bring it within an exception, or he'll argue it isn't hearsay.
Well, I guess my first argument is that it's not even hearsay because there's no statement. But if the court is implying that it is, then
Wait a minute, how's there no statement? If he learned after talking to her, no matter how you phrase it, he learned based on her statement, right?
he learned pursuant to his investigation that the individual had turned a different way. But hearsay is when we're introducing a specific statement. There isn't a specific statement that the officer is testifying to. He's not saying John Doe stated X, Y, and Z. He's just saying, I had a conversation.
It's still based on hearsay, no matter how you cut it. Otherwise, you could get around the hearsay rule every single time. It'd be like anybody asking anybody, what did you learn after speaking with them? That statement is still hearsay. I'm going to find that it goes to the declarant's state of mind, and I'm going to allow it.
Understood. Thank you.
Ask your
During the hearing, Mr. Muhammad repeatedly questioned the officer about what the gas station clerk had said. Each time, however, Judge McNally sustained the defense attorney's objections, citing hearsay. Under Rule 801 of the Michigan Rules of Evidence,
which closely mirrors the federal rules of evidence and similar state regulations, hearsay is defined as an out-of-court statement presented in court to prove the truth of what that statement asserts. In simple terms, a witness generally cannot testify about what another person said if the intention is to use that statement as factual proof. For instance, if a police officer testifies that a bystander claimed the defendant fired the gun, that statement would usually be inadmissible because the bystander isn't in court to be questioned under oath. There are, however, specific exceptions. Some out-of-court statements may be accepted if they meet one of the recognized exceptions to the hearsay rule or are introduced for another valid reason, such as explaining an officer's decision-making or actions during an investigation. In this situation, Judge McNally decided that the officer's recounting of the gas station clerk's comments qualified as hearsay and could not be admitted as evidence. As a result, the court excluded those statements from consideration.
Did you learn based off of your discussion with the clerk the street that the defendant had fled from? That the defendant had turned onto?
West Road.
Okay, and do you know what the posted speed limit is at that location on West Road?
35 miles per hour.
Okay, no further questions.
Did you ever apprehend the defendant?
Me? No.
Okay. Ask your next, any cross? Do you have cross?
Just 1 second, Judge, I'm thinking, right? real
Okay,
quick.
take your time.
Just one question.
Yes, ma'am.
You weren't sure at first who the person was because it could have been a host of people. Is that fair to say? Like, you said you thought it was the brother.
No.
Well, wait a minute. The brother's name is one of the Blues, right?
Are you?
So you didn't know who the person was. Is it fair to say at first?
I did not know that.
I don't have any other questions.
Mr. Mahan,
No further questions.
you can step down, call your next witness.
No further witnesses from the people.
You have no further witnesses. What are you gonna do?
Judge, I'm gonna motion for a bind over, I believe. Testimony reflects a question of fact, the trier fact, and I'm gonna reserve any remark.
Any argument, Ms.
Oh, I
Diallo?
object to any bind over on these particular facts that were presented. We don't have identification. There are a whole host of things that are wrong with this matter. For probable cause, we object.
Mr. Muhammad?
Judge, in regards to identification, the officer indicated that he made contact with the defendant at the scene, and he identified him as being that person here in court today. I think in-court identification is sufficient for probable cause. We're not here determining guilt, just whether or not there's probable cause of a crime, and I believe we established that on this record.
Anything else, Ms. Diallo?
No, Judge, you've heard the facts of this particular case. I think I don't know what happened out there, even by probable cause standards, but I believe the officer testifies the person that he thought was doing one thing wasn't doing what he thought. It was the wrong car. It's a mess. It's Judge. We don't think there's probable cause at this stage, so for that, we would ask the court not to bind over.
And Judge, may I have a brief response? In regards to the R&O, the officer indicated that he was in full uniform and that he made contact with the defendant. He gave him 2 lawful commands, at least from what I recall, to stop, and the defendant did not stop. He then fled from that location. The officer he gave the defendant voice. The defendant was a driver of the vehicle, and he gave him voice signals to stop. The officer was in full uniform, and we also learned that the defendant did not stop and willfully fled from this scene. Shortly after, we learned that the posted speed limit on West Road was 35 miles per hour. I know in regards to learning of the 35 miles per hour, it wasn't the officer who had personal knowledge, at least did not appear that way to me. So in the event the court is not inclined to bind it over on the fleeing 3rd degree, I would request it be bound over in 4th degree. Nonetheless, I do believe, because today's probable cause testimony is sufficient as charged, but if the court is inclined not to bind over on the third degree, I would request that it would be done in the fourth degree. Thank you.
Any response to that?
Judge McPhail ultimately determined that the gas station clerk's statements qualified as hearsay, but permitted the officer's testimony under a recognized exception known as the declarant's state of mind. As discussed earlier, hearsay is any out-of-court statement presented in court to prove the truth of the matter it asserts. In this case, Mr. Muhammad argued that the officer's reference to the clerk's conversation wasn't hearsay, because the officer didn't repeat the clerk's exact words. However, the rule makes clear that a verbatim quote isn't necessary. Even a paraphrased or summarized version can constitute hearsay if it's introduced to prove the accuracy of the original statement. Certain exceptions, however, allow hearsay to be admitted as evidence. Under Rule 803 of the Michigan Rules of Evidence, one such exception applies to statements revealing the speaker's then-existing mental, emotional, or physical condition. This includes expressions of current feelings, intentions, or state of mind, which may be used to show that the person's mental or emotional state matched what was described at that moment. In this instance, Judge McPhail found that the clerk's remarks reflected his own immediate thoughts and emotions rather than factual claims about another person's behavior. Because the statements described the clerk's present mindset, they fell within the state of mind exception. Consequently, the judge allowed the officer's testimony to be entered into evidence under this specific and well-established exception to the hearsay rule.
I'm talking about with his request to fourth degree.
So, hold on, I'm pulling it up right now, Judge, so I know the third degree should have fallen, with this particular set of circumstances. I'm pulling up fourth degree right now, but we still, how we get past the, identification therein? You said you went after one car, and then it actually was a different car. So I don't know, Judge, but the fourth degree I'm trying to pull up right now.
So essentially, it's just about the 39.
Yeah, but not only that, Judge, but he didn't even have his lights and sirens on. Remember, he said he didn't. I heard that. Hold on. He said he didn't have his lights and sirens on for number one. But I'm gonna pull it up right now, Judge, to see what fourth degree looks like.
And Judge, just
I've heard enough. I'm troubled here because what you have is an officer that was called, seemingly doing the right things, going over talking to a clerk, deciding he needs to make contact with the subject, goes up, makes contact with the subject, tells the defendant, in this case, Mr. Velo, that he shouldn't leave, that he didn't want him to go anywhere. But the very essence of fleeing and eluding is that he's fleeing and eluding the statement. I'm troubled because in this case, you're right, Ms. Diallo, he did not have his lights on. He was not pursuing the vehicle he was not pursuing the suspect vehicle. He didn't know where the suspect vehicle went. For all we know, the suspect vehicle, I shouldn't interject in the record, but there's an area there where you can easily get to a 25-mile-an-hour speed zone. The officer was never in his vehicle chasing him. He thought he went elsewhere. The clerk tells him something to do that as to the fact that the defendant traveled on West Road. We don't know if he traveled on West. The officer thought he traveled on Fort. He observed the vehicle that was traveling west or eastbound on West that turned left against a no left turn signal onto northbound Fort. So we honestly don't know where he went, and the officer was not pursuing him in a vehicle. I'm not even going to bind over on flee and elude 4. I'm going to dismiss. I'm going to dismiss flee and elude 3rd. However, I do believe in the face of the questions or the answers that were, hang on.
sorry,
I'm not going to change my mind.
I understand.
I do believe that there's sufficient evidence, though, to establish that the defendant committed the offense of assault, resist, and obstruct an officer. How successful you'll be in a trial, I don't know, but I'm going to bind the defendant over specifically only on count 2. Count 1 is dismissed. This is interesting. I can't say I've had this one come up, but I do think that there just isn't sufficient evidence to establish he was fleeing and eluding at that time. So I'm gonna dismiss that count. Let me just make a note here, please.
Mr. Muhammad argued that if Judge McNann decided not to elevate the charge of third-degree fleeing and eluding to circuit court, the case should at least be transferred as a lesser fourth-degree offense. Under Section 257.602A of the Michigan compiled laws, it is illegal for a driver to intentionally ignore a police officer's order to stop, whether by speeding up, turning off the car's lights, or otherwise attempting to evade law enforcement. In Michigan, fleeing and eluding is typically categorized as a fourth-degree felony. However, if prosecutors can show that part of the chase occurred in an area with a posted speed limit of 35 miles per hour or less, the offense can be raised to third degree, carrying a more severe penalty, up to 5 years in prison. This classification depends primarily on the chase's circumstances, particularly the speed zone involved. Therefore, Mr. Muhammad maintained that if Judge McNann found the evidence insufficient to prove that Mr. Bello was fleeing in a 35-mile-per-hour or lower zone, the appropriate action would be to bind the case over as fourth-degree fleeing and eluding. This approach, he argued, would recognize the seriousness of the conduct while remaining consistent with the strength of the evidence presented at the preliminary hearing. Judge McGuan ultimately chose to dismiss the charge of fleeing and eluding, concluding that the officer never actually tried to stop or pull over Mr. Bello after he left the gas station. Since there was no evidence of an attempted traffic stop, the legal grounds for the fleeing charge could not be supported. However, the judge determined that there was enough evidence to send Mr. Bello's case to circuit court on a different charge: assaulting, resisting, or obstructing a police officer, under Section 750.81d of the Michigan compiled laws. This law defines obstructing as knowingly refusing to follow a lawful command or order from a police officer. Judge McGuan likely found probable cause to believe that Mr. Bello deliberately ignored such an order when he drove away, even without a direct chase. At present, the obstruction charge remains active, with a jury trial scheduled for September 8, 2025. We'll keep monitoring this case and provide updates as it unfolds. If you'd like us to cover more real courtroom stories or explore other legal cases, share your thoughts in the comments below. Thanks for watching, and remember to like, share, and subscribe to support our mission of promoting a more informed and justice-aware community.